All right. Good afternoon, everybody. Welcome to Association Leadership Season 2, Episode 11, a return to normal, what to expect when we do return to normal. I wanted to introduce myself. My name is Craig Vaughn. I'm the president of the Castle Group, and I will be your host tonight. And we have Jeff Rembaum back. Of course, Jeff, welcome back. And Lisa Mcgill, a special guest, returning again. So welcome, Lisa and Jeff. Before I have them introduce themselves, we want to just talk a little bit about what we're going to do today. So we're going to do some polling again. We're going to put you to work, and we have some check-ins on what people are doing with respect to their amenities. I wanted to start though, Ness, if you could post, let's get going right away. Post a poll question number 1. What type of community do you live in? So we'll get a feel for who's here. And then again, welcome Jeff and Lisa. I want to remind everybody that they're not here to give legal advice for your association, but rather just to give their opinion on the things we're talking about. Obviously, if you have specific questions, legal questions relative to your association, you should reach out to your own counsel. Jeff, can I ask you to quickly introduce yourself and the firm?
Well, sure. Hi, everybody. You know who I am. And I'm going to guess that most of you know about our firm. But you're used to me starting out by saying we're comprised of 19 lawyers, and a week will be comprised of 20 lawyers. We're growing our litigation department. As you know, we specialize in representation of Florida's community associations, developers who build them on occasion, and also the unit owner claim when appropriate. Offices are in Pompano Beach, Broward County, Palm Beach Gardens in Palm Beach, Hillsborough over in Tampa, and Miami-Dade by appointment. We publish 2 publications regularly. My partner, Robert Kay, publishes Legal Morsels. I publish Rembaum's Association Roundup, the community association news you can use. Attorney Robert Kay hosts a monthly radio show from 6 to 7 on channel 1470 and channel 95.3 FM. Peter Mullengarden, another partner of ours, hosts a weekly radio show, Condo Solutions, every Monday from 9 to 10 a.m. on channel 1450 a.m. You can link into both of those shows through the kbrlegal.com website. So there's links to both of those, kbrlegal.com. We provide numerous monthly webinars on a whole variety of subjects, and we are super honored and thrilled to have Lisa Mcgill with us today. Lisa, why don't you tell everybody a little bit about you? Most everybody in the state, I think, knows you by first name and knows how what an expert you are in this field.
Well, thank you for that glowing introduction. So I think you did a very comprehensive job telling our participants about the resources offered by the firm. I reiterate to go to our website to look at all the different articles and webinars posted that address the COVID-19 crisis, as well as just general association operations. I'm happy to be affiliated with K. Bender Rembaum, and in addition to being board certified in condominium and planned development or planned unit development law, I'm also a fellow of the College of Community Association Lawyers, which is a national accreditation by Community Associations Institute. So I'm happy to participate to the extent that is necessary, and look forward to addressing your questions today.
You'll find few attorneys in the state of Florida that have the knowledge of community associations and the history that Lisa Mcgill has. So we're honored to have you here.
Interestingly, every property manager thinks they have that same expertise, which is part of the problem. So, well, Lisa and Jeff, welcome. I do want to remind our participants to chat in your questions, and we'll try and get to some of those and work them into the discussion today. And so what I want to do, let's show Mirnes who's in the audience today. So we have, interestingly, about half and half condos and HOAs. We have 1 co-op, so we do appreciate you listening in on the co-op side. So about 50-50, guys, just so we know. Half of the HOAs are 55 and better communities. So we have some specific items to address there because we have a couple of vaccine questions for everybody. So before we jump into the main topic today, we just wanted to cover a little bit of ground. Number 1, the emergency order without fanfare was renewed on Friday for 60 days. Interestingly, when I look back at the order, the first order from the governor with respect to the emergency declaration was March 9th, 2020. So we have come almost a full year under emergency order, which I don't think any of us would have believed when we got the first one last March 9th. But anyway, it was set to expire February 28th. It was extended for an additional 60 days. A quick question I want to ask our audience, Ness, is number 6. We're going to go from top to bottom to top here with respect to questions. Poll question number 6. Do you think this will be the final extension? So let's just see.
You should have offered a prize on this one.
Yeah. Well, we guessed last time it may not have been. Oh, last time we guessed it would be. So we were winners. But Lisa, what do you think? Is it going to be, is this the final one?
In Florida, it's hard to say, but I would anticipate extending it one more time afterwards.
I agree.
Yeah.
If the president's plan comes to fruition, that there'll be enough doses for every American by the beginning of May or end of May, heard on the news this morning, then I think that will fundamentally change the landscape.
Okay, well, Marinez, let's show what our audience thinks. They align well with you guys. 50%. 18% don't know, of course, none of us know, but 50% thinks that there will be at least one more extension. So we have some time, although 32% are saying, yes, this is the last one, which really leads into our discussion today is what do you need to do to prepare for when the emergency declaration is lifted? Excuse me. What I want to move on to now is just to check in on amenities. One of the big piece of feedback we get from our listeners is they want to know what everybody else is doing. And it's been some time since we checked in on what is open and what is closed in our association. So what I'd like to do is, Marinez, can you post poll question number 2, please? And have you open your pool, your gym, or your clubhouse? 3 parts to this particular question. We'd like you to go through that and remind everybody, but that the last time we did this, almost all pools were open with restrictions. Almost all gyms were open with restrictions. And only about 25% of clubhouses and common areas were open. So let's check in on where we are now. And then maybe you guys get your comments. So Marinez, let's end the polling. We'll end the polling quickly. Most people are in. So if you look at is your pool open? 86%. So there's still some closed out there. Everybody, is your gym open? About half. That's a little lower than we have seen in the past. And then have you opened your clubhouse? Still around the 25% total. So that's kind of where we are. I would say the gym and the clubhouses, gym's down from what we saw last time, which is interesting. Jeff and Lisa, your thoughts on the status of things out there for your clients?
Lisa?
I'm actually surprised to see the gym. Certain associations have opted to retain keeping the gym closed. I'm not surprised about the pool. I mean, especially now that it's vacation time again. Remember, this whole thing started the very beginning of March, right when spring break hit, and the beaches were closed and everything was closed. So going to the pool quickly became one of the main options for recreation within a neighborhood or a condominium community. I'm surprised to see that more gyms are closed, but that could be because there is a lack of ability to monitor them, or maybe concern about cleaning and sanitizing the gyms. Clubhouses are a little bit more problematic because it depends on whether or not you have staff and what kind of services are provided in a clubhouse and who's going to monitor to see if social distancing is maintained. So what are your thoughts, Jeff?
I was surprised. In the past week, I've had some inquiries regarding opening of amenities. Just generally, can we open our pool again? And can we open our clubhouse? And it occurred to me that the message that the emergency orders that closed all of these amenities down not necessarily has not been communicated adequately back out to the constituency, to the citizens out in Florida, that those parts of the emergency orders have been lifted, and all that's really left is CDC social guideline to maintain the distance, and then wearing the face masks is presently still there. So I was surprised to see that a variety of different, and when it wasn't limited to just condo or HOA. So for several of them to reach out and to have that discussion with me about reopening, and they were closed, I was just surprised that they thought the emergency restrictions were still. I was surprised that they didn't know they were lifted, would be the best way to say it. With that in mind, I think it's time. I don't know that it's time to open the clubhouse up for Broadway shows yet, but I think it's time to open the clubhouse to let people come in there to get to the swimming pool, as long as reasonable precautions are taken. And what does that mean? I'm suggesting to client base that very simply, if you're going to open the gym, put some signs up. Number one, let's use it at our own risk. I think that makes sense. It should be there anyway. And then normal type cleaning. Wipe the equipment down before you use it. Wipe the equipment down when you're done. And the important part is, by doing that, you'll get 2 cleanings of that equipment before the next user actually uses it. So I think that's just prudent advice, even under non-COVID circumstances. I think that's smart to do. But I think it's time we started slowly and carefully getting back to normal. Seems like we're heading in that direction.
In fact, we're going to ask that question in a second. I think what we found with our clients is there's no lifestyle programming going on other than virtual. And so the clubhouses are drivers for that lifestyle programming, the card games, the shows, the, whatever, the speakers and all those things. And because there's none of that going on, there really isn't a big demand to open the clubhouse. Once you start getting into that stuff, then you're going to get more activity and those types of things.
Sure.
Nez, let's post poll question number 3. So with the leveling off of positive COVID cases in the last 30 days, I'm going to ask our audience if they have considered changes to their use restrictions at this time. Can you go down a bit? So let's see what's going on, and then I want you guys to take us through. Again, you kind of commented on what's going on. A lot of no changes we're seeing right now. Some have started to decrease 20%, 22%. Let's give it another second. There's still some answers coming in with respect to the opening of amenities. And Jeff, when I get there, we're going to ask you a question around, if I've opened my clubhouse, what are the rules? Are there occupancy rules? Are there, what rules am I required to follow? And then, what do you recommend? So Nez, let's show the results. Here they are. So very few, 3 participants have increased their use restrictions. 20% have decreased their use restrictions. Jeff, to your point, it's starting to maybe open up a little bit. And a lot of the people at this point have not changed. At Castle, we're kind of advocating for no change. We're so close to the end of this that if we just can hold on and be, patient, we hope there's an end in sight. And now's the time to be more diligent than almost less. But thank you, Marinez, if you can take those down. So some decrease in use restrictions. Jeff, to answer a specific question from one of our listeners, they just opened their clubhouse. What rules are they restricted by in terms of occupancy, social distancing, masks, those types?
There is no occupancy restriction. Obviously, I think you want to be smart about it. So you would want to continue social distancing. You would want to have a sign on the front door, masks are required, and make sure people are wearing their masks. Those are the only real precautions I think you should take to protect the association. And then you can take more from there. If you want to be more restrictive, but you don't want to be less restrictive than at least requiring a face mask and social distancing, than anything else you might want to do. I'm comfortable to the point where I bought tickets for a show in November. So I feel like by November, it was probably not throwing my money away to take a chance to buy tickets to a show where there'll be, 500, 1,000, 2,000 people. So I'm cautiously and hopefully optimistic that we are really coming into the tail end of this thing.
Yeah. And I think, Lisa, as I understand it, there are no specific requirements now with respect to emergency orders, other than the practical common sense, wear a mask, social distance, those types of things. Is that where we're at?
Well, in Broward, the current emergency order still prohibits gatherings, limited up to 10 people for gatherings, not including the household in which the gathering takes place. So yes, I mean, as far as clubhouses are concerned, unless social distancing can be maintained, those card games are somewhat suspect, or some of the other activities that would take place are somewhat suspect. I can say that in Broward, there was a curfew. The curfew was invalidated by a court back in December. And just recently, I think it was only a week ago, that the appellate court confirmed the invalidating the curfew. So the bars and restaurants are open, people are happy, but and I don't really see out in public much enforcement of even the mask mandate. So I encourage my clients to be more careful, not only for their own health and safety, but to minimize or at least try to not to prolong all the nonsense that we have to go through and that we've been through for the last year and a half. I guess.
Right.
Seems like even longer.
It does seem longer than that. What about, and Jeff, nothing in Palm Beach anymore? No monitoring of amenity usage?
Correct.
None of that stuff, right? So I see a question about tennis and pickleball. Do we still need supervision? Not required any longer. So
correct.
Not in Broward either. So you don't have to have supervision, but again, you can't have 10 people at the pickleball court if they can't maintain their social distancing.
Yeah. So we want to maintain the CDC social distancing guidelines. And we want to maintain the wearing of face masks. Everything else the association does, it probably is going to relate to that specific community and have a reason why that community feels they need a heightened restriction.
Right. Okay, well, let's move on to something a little more maybe controversial. Ness, I want you to post question number 4. A couple of these are vaccine related questions. Have you had a vaccine? Just number 1. So to get a feel for our audience and what that looks like relative to the greater population. And then as an association, are you considering mandatory vaccine policies for the use of amenities?
Boy, I hope that's on our question list to talk about that number 2 question.
We are going to do that right now. In fact, Jeff, when we talked about it yesterday, this is a slippery slope. And I'd be interested in your advice for communities considering mandatory vaccine policies for the use of their amenities.
Jeff, go ahead.
No, I think, Lisa, your expression right then said it all. No, stop,
No.
Don't, right? Do not create this 2 classes of membership for your association, those who have the vaccine and those that don't. Everybody has the same rights to use the amenities. You need to apply your rules evenly across the board. Not to mention, we're not even getting into HIPAA laws. We're not getting into the fact that associations can't share medical information that they acquire about owners in the first place. The last thing I think an association wants to do is start to accumulate that information because it begins to open them up to liability. Lisa?
I wholeheartedly agree. If the government can't require you to be vaccinated, how can a community association require you to be vaccinated? And all owners have use rights for the common elements. They have the easements of use of those common elements. So differentiating based upon a personal health choice is inappropriate, would not be upheld, in my opinion.
Okay, let's see what our audience had to say. Have you had a vaccine? So 70%.
Wow, that's great.
I think
I'm
that's
jealous.
a good indication
I'm
of the
jealous of
number
that
our-
70%.
That's our 50 and 55 and better communities up there.
Way to go, everybody.
Helping it. Good job. And then, are you considering mandatory vaccine? Are you going to slide down the slippery slope? Very few, right? 7% said they were considering mandatory vaccine policy. So I think your advice is well placed, and it is, then you get into where you keep that data and who has access to it and all those types of things.
Craig, I'd also add that for those 7% that answered yes, please, before you actually take action, please reach out to your association's attorney and have further discussion regarding that, because there are some significant legal implications associated with it.
It's a great point. Okay, well, before we move off the amenities and use restrictions and get into the what happens if and when the emergency order is lifted, just a couple of quick questions I want to clarify for our audience. The executive order doesn't say amenity restrictions have been lifted. That isn't the case. There are certain rules relative to amenities, but mostly association rules at this time. You still have the right to restrict usage, which we're going to talk about. And the amenity, the pool monitoring is no longer required. So I just want to clarify those 2 things. Let's pivot to the executive order. It is going to be lifted at some point. Not in the next 60 days and possibly not the next 60 days, but now to some extent is the time to act. So what I wanted to do was take our listeners through the process. And first of all, Lisa, if you can remind everyone of the main things that the emergency order allowed associations to do that they would not otherwise have been allowed to do. So let's start with the top. What are we doing because of the emergency order? And then how we're going to change when it's lifted.
Well, invoking the Emergency Powers Act, I mean, the primary issue that was encountered by associations were meeting notices at the time that it was improvident or impractical to provide meeting notices. Of course, now there's really no urgency in holding meetings or other that would preclude anyone from providing a notice in a timely manner, and the ability to restrict or declare unable for use certain portions of the condominium property or association property, particularly the amenities. But I have to tell you that associations can go too far. And one example of the association going too far just happened here in Boca Raton, Florida, where the association deactivated unit owner fobs once they learned they had been diagnosed positive with the COVID vaccine. Now, of course, the association took that action on the basis or with the justification that there was endangering the lives and the health of the other residents and the staff members. But they were sued. They were sued very significantly for false imprisonment and violation of the condominium documents and all kinds of things that now both the association and the management company need to defend. And they're going to have to be in court to say that those rules, particularly as applied to the particular couple, were reasonable, were within the powers and authorities set forth in either the condominium documents or Florida law, and were actually designed to obtain a legitimate association objective. So I think preserving the health and safety of your residents is a legitimate association objective, but could it be reached in other ways other than deactivating fobs and prohibiting their access throughout the condo?
Right. Was that the one where the lawsuit was filed, Lisa? False imprisonment, what have you?
Do we know what's going on in that lawsuit?
Well, I do. I looked at it. Both defendants filed motions to dismiss based upon various grounds, indicating that the emergency nature of the time and that CDC guidelines did require quarantining for 14 days once you were diagnosed with the virus. The hearings on those motions are coming up not in the not too distant future. Of course, the way that lawsuits work, a lot of technical grounds for everything. So this could be tied up in the pleading stage for a very, very long time. But the unit owners in this particular situation, I think had somewhat of a position that they can vindicate through the legal action.
Mm-hmm. Well, I'm happy to say that is a competitor of ours. So they're blazing the trail in that lawsuit. So we're watching from afar, and I'm sure the first of many. There haven't been very many cases, but the dust will settle soon enough, and I would expect we'll see some more litigation.
Well, that brings us to some of the legislation. I mean, I know we're going to talk about it in a little bit, but Florida and the federal government are both considering enacting legislation that provides for limited immunity under certain circumstances. Sorry.
Well, that's a little tease for our legal update after. So let's just move on to back to the executive order for a second, emergency order, excuse me. So what associations did is they were allowed to have non-notice board meetings, which I think we've advocated for not doing.
That's not true. That's not true. It's not non-noticed board meetings. They were allowed to reschedule board meetings. Never said non-notice.
Okay,
or notice as practicable. So if the notice was, you couldn't do a 14-day notice, you couldn't do a 2-day posted notice, then you would have to give notice as readily available as was.
Say your manager was out because they had COVID and half the board was out or something, and practical under the circumstances.
Right. We restricted access to the communities and then and restricted access to amenities. So Craig, now it gets lifted, Jeff. Does that mean everything goes back to normal right away?
Right away. Well, and I think it depends how you define normal. For example, how many of us were surprised to learn that we didn't need the emergency order in the first place in order to have remote, i.e. virtual, board and membership meetings? There's already a mechanism in the Not-for-Profit Act, Chapter 617, regarding how to do just that. So, I think it's the new normal is electronic and virtual meetings. There's been a tremendous increase in electronic voting, and I think that trend is going to continue. And I think, sometimes we can look at a bad event and find some good that occurred during the bad. And there is some good that occurred during the past year as related to our community associations through COVID. And that happens to be the use of technology. I think it forced a lot of associations to embrace the technology that otherwise may not have occurred for another decade.
Mhm. And guys, so that's a fair comment. And then let me just ask you, we talked a little bit about it yesterday, that, once the order is lifted, that the debate changes on keeping your amenities closed, right? And in that, now you really have to, right now, you can, under the emergency orders, I understand it, really limit the use of your amenities. When the order's lifted, now your argument is going to be, we really need a reason to keep the amenities shut. Do I have that right?
I think so.
You're gonna have to revisit your rules and regulations and determine what's going to be in the best interest of the community, because board rulemaking power is limited. It's limited to the reasonableness standard, which of course is very hard to define, and it's also limited by refusing to conflict with any of the rights afforded by any of the other governing documents. So as I talked about before, you have that easement and right of use. Does that mean that easement and right of use means for all hours the facility is open? Does that mean it's reasonable to limit, certain numbers of people during certain hours? These are all things that the associations are going to have to take into consideration, and also depending upon the actual usage in their community. They may have particular times where they have a very, very dense usage that could justify maybe restricting or making appointments for usage. But otherwise, they're going to have to show that any of the rules are legitimate, are designed to legitimately address an association issue.
Okay, well, Lisa, I appreciate that, and I think it's going to play out, and I guess it's at what point does the debate happen, and it doesn't really happen until we see how the vaccines roll out and when the orders are lifted. Jeff, let's move on for a second. We have an opportunity. We've learned a lot in the last year. Is there anything the association should be doing to maybe amend their documents to put in some of these emergency powers that maybe weren't specific in their documents?
I like that idea very much. Lisa, I know you worked on that for some of your clients, and you've adopted, or you were working on drafting some emergency powers to put into the deck that were modeled after the state's emergency powers with some modifications. And I think it's a very clever thing to do, even going forward and taking communities out of the ground. One of the things I'm considering is putting in a new section into the declaration dealing with the emergency powers, so that the association can act faster if it wants to than the state and local governments can, without putting themselves in legal jeopardy, such as the ability to close the amenities under certain circumstances where the state emergency order may not be quite out there yet. So I think there's a reasonableness standard that has to be implied with that as well. I think the ability to have the virtual meetings should be codified. Even though we have the ability in Chapter 617 to have those remote board and membership meetings, I still like the idea of flushing it out and putting the process in. For example, how does the member get their right to speak during the virtual meeting? I don't like that. I've heard some associations, they have to write their question in. No, that's not what the law provides for, right? Every member gets that right to comment, up to 3 minutes, give or take. So I think that we need to codify the process into our governing documents as part of amending and restating governing document projects.
Okay, appreciate that. And Lisa, what do you think is here to stay?
Well, definitely, Jeff mentioned it earlier, the remote participation in any type of meeting, whether it's committee or a casual meeting, board meetings, association meetings. My clients are telling me that they have far more participation now than they ever had in the past, and it's actually served to improve their operations, not diminish them. Embracing all kinds of technology. I mean, you could have concierge services provided through applications or computer programs rather than having a live person. You may have guest restrictions or other types of technology solutions for like package deliveries. I think that's definitely here to stay, because
Right.
after the last year, I think I saw one statistic that said there were 70% more deliveries than in previous years. So I don't think people are going to refrain from ordering items off the internet and expecting their food to be delivered, their groceries to be delivered. So how do you actually get those deliveries from the front door of the community to the individual homeowner's property are going to be issues that people are going to have to address.
It's funny, I can tell you in some of the condo buildings we manage, the increase in packages has been a real challenge, especially for some of the older buildings when there wasn't any, delivery. So just where you're storing the packages for your residents, and it's quite a process. And where space is getting repurposed, all those types of things.
And when
I also think that you raised a good point, that people are going to, or community association leaders are going to start repurposing outdoor spaces or creating more space for activities to take place that are conducive to the Florida environment, like shade structures and what have you, more air conditioned areas, so that people can be distant from each other and also and enjoy the condominium facilities, the facilities.
perhaps a well-known management company might use their lobbyists to sponsor legislation such that the use of a conversion of a utility room, of a small conference room, doesn't, for association purposes such as the storing of packages, doesn't constitute a material alteration requiring the vote of the membership. Because remember, when you start repurposing these rooms, you are creating arguments that those are material alterations requiring a vote of the owner. So watch out for that.
No, I think it's great. I think it's a great point. The other ones on my list that I think are here to stay, Lisa, you said technology. I agree. I think e-voting is here to stay and will grow. I think accepting correspondence electronically is here and will continue to grow. I had on my list improved communication. I think the successful communities that have worked through this have really improved their communication to residents, to let them know what's going on. And, whether it's by mobile app, whether it's by e-blast, I think that communication process will, between a community and its board, and an understanding of why decisions are getting made, will continue. And I think is a big one. And then we also think amenity scheduling is here to stay. It's very convenient for everybody. You don't have to worry about going to the gym and is my treadmill going to be ready and is it not? So we see some of the amenity applications that you've always booked tennis courts, you've always booked bocce courts, but not always booked your workout in the gym. So we think some of the amenity scheduling stuff is likely here to stay as well.
Interesting.
Okay, so now let's do the big test before we go on to some legislative stuff. Marinez, let's see who actually has a plan for the lifting of the emergency order. So can you post question number 5 for our listeners? Do you have a plan if emergency powers are not extended? And let's just see who's hitting this between the eyes or is standing back and going to react when, in fact, the emergency order is lifted. I think the obvious question, Lisa, is do you need a plan?
Well, you're definitely going to have to revisit any rules or policies that were implemented during the COVID period. The worst thing that an association can have is rules on the books that are just ignored or not enforced, because that can jeopardize the enforcement of some of your other rules. So you're going to want to take a look to see what you've adopted, whether they need to be changed, which is likely, and how they can be changed to continue the benefits for the majority or the vast majority of the members. With your staff members, you may have some changes that you may want to implement. I mean, again, if you've made changes to hours of staff hours or change where they were situated in the building in the past, you may want to revisit that and put people back into the office or remove plexiglass barriers if you've installed them. But again, I want my clients to be conservative to the extent that they can, because I want them to protect not only the health and safety of their residents and their staff, but to ensure or try to minimize the prolonging this whole coronavirus pandemic nonsense. I mean, again, we've been so stifled in how we can do things, and maybe people are getting used to it, or conversely, maybe they are fatigued and they're sick of it, but anything that you can do to thwart it is really going to be beneficial for everybody going forward.
Yeah, I think you made a good point. My partner last week or 2 weeks ago on his webinar, they talked about the increase in emotion and frustration and fatigue in the community, the mental issues associated with you being locked down. And it was amazing. I think 80% of the respondents said they noticed in their community a higher level of intensity, let's say, than pre-pandemic. So it's a real illness. Mental illness is a real illness, you know.
Well, and you talked about what things are here to stay. Maybe implementing new programs, procedures that are designed for mental health purposes. You know, maybe some associations are going to have mindfulness seminars or health related seminars or offer health, type of fairs where people can have access to resources that can help them negotiate and handle the close proximity that you have in these community associations.
Yeah, that's interesting. Okay, well, guys, let's move on from the emergency order lifting. Oh, let's post the results if you can, Marinez, of the poll question. Do you have a plan? 169% don't, 13% do. I think it's probably, we didn't know what was going to go on with the emergency order. It's probably something an association should start thinking about. I know we're advocating for our associations to just get in front of it. Like, you have to have a plan. Like we had a plan for shutting down amenities, we do have to have a plan for opening everything up again. And what does it look like? And what are the benchmarks for, free moving all the pool furniture back to the pool? So you don't have to guard, you don't have to self social distance and things like that. So what does that plan look like? What are the thresholds? So anyway, okay, let's move on. Let's move on to the 2021 legislative forecast. Lots going on. Of particular importance to our listeners is SB 1916, the legalization of recreational marijuana. Maybe that will help us get through some of this stuff. It is very important, though, to know that while you can't smoke in the clubhouse, you can create the same sense by smoking, closing your eyes, and thinking you're in the clubhouse. So we have some opportunities. But in all seriousness, the legislative session opens, and like anything in Florida, it's complicated. It opens the first Tuesday after the first Monday in March. So it's a riddle. And I solved the riddle myself. March 9th is when the legislative session opens, exactly 1 year to the date when the first emergency declaration was placed. So a little irony there. But I want you guys, if you can, there's lots going on. You teased us earlier, Lisa, with the immunity demands, but if you can take us through some of the big things that we can expect to hear, and maybe how we can get involved if we need to.
I think that there's definitely somewhat of an effort to try to, in some respects, micromanage community association operations, but in other respects, expand the discretion of community leaders. We have one proposal out there that talks about investment of association funds, expanding the types of investments that would be available for associations so they can feel comfortable that they're engaging in prudent investor rules. But the way that the legislation is worded is it's pretty onerous. It requires the community association to have an investment plan, to share that investment plan with a licensed investment advisor. The investment advisor has to be a fiduciary, and that's a kind of a term of art, and that was something that was changed during the Trump administration. So many investment advisors do not want the option of becoming a fiduciary because it does limit them in making good choices for their clients. And then, of course, you'd have to have disclosures, very, very frequent disclosures, annual CPA review of the investments, and of course, how you describe the investments to your members. I think there's going to be a lot of hesitancy among community leaders to engage in any type of investments that are speculative and that can result in a loss of the association's assets. I mean, that's, I think people are a lot, even though we're earning 0.25%, they have to, take it by the chin and take it, as opposed to being more aggressive.
Before you move on, I definitely want to comment on that one. It's funny you opened with it because of all the bills, and there's a plethora of bills. My desk is just covered with all the community association bills preparing for today. And this one is, to me, one of the three most dangerous pieces of legislation sitting out there. We're talking, has to be a legislator's family member or someone is, lobbying, if you will, on behalf of an industry to do something absolutely, I think, I'll use the word asinine, for the money that's supposed to be there in 20 years to put the new roof up. And you get some board that has a higher risk tolerance, and all that money is now invested in the open market in a silly way, but still lawful. And that money is gone.
Yeah.
All right. Simply gone. In the past, we've heard about people who have stolen money from associations, and shame on them for that. We've never heard of, hey, this money for the reserve account was put in the wrong place, and what should have been 500,000 or 2 million is only worth 100,000 now because of a bad investment. Well, if this bill becomes law, that's exactly what you're going to start hearing about. And I'm going to start drafting in my governing documents provisions that will prevent operation for associations, or at least give them the choice that they can restrict future boards from being able to make that type of speculative investment. You want to do it with your own money and you want to go gambling, you do that. But this is nothing more than legalized gambling for community association money at the hands of who, right? No, this is a very, very, very bad idea. For those that want to follow it, it is, what is it, Senate Bill 1490, reserve investments. If you read through it, it's just, it creates opportunity. I'm not worried about fraud. I'm worried about bad decision-making. I'm worried about brokers who may walk away with reserve money. A whole host of other worries come up when we're talking about reserve investments. And this is supposed to be fiduciarily, conservatively invested. And now all of a sudden, all the brakes are off and you can just gamble with the money. I don't like it.
Well, Jeff,
I don't know if I would agree that, all the brakes are off and you can gamble with the money. There definitely are strict rules that are taken into consideration. But again, I just don't see many associations taking advantage of it. And I also think compliance with all of those Picayune type rules is going to be an issue because again, you have to have the CPA, you have to have the investment advisor, there has to be licensed, you have to have the annual plan, who's authorized to make the plan, how do you make the plan?
And the stock market goes
there are
to
a lot of enforcement
right,
options.
then the investment market goes down and all that money is gone.
Yeah.
And
well,
we advocate a strategy
for our residents.
We advocate a strategy that guarantees the return of your money and not worry about the return on your money.
Right.
You get an FDIC insured and you take no risk, but the money's there when you need to do the,
Right. I like the fellas that there's a lot for the listening audience. There are industries out there that ladder CDs, so you don't have more than 250,000 at any one particular institution. So if you have reserves with several millions of dollars, you can protect that money and then get account statements that aren't 15 different account statements from 15 different banks. It's all consolidated onto one 8.5 by 11. It's rather clever and it's a smart thing to do.
Yeah, you should be. It's a good point for treasurers out there. You should be talking to your advisors. There's laddered CD programs. There's CEDARs. There's there are there's a product called ICS, which is a interbank cash sweep facility, which does the same thing. It just multiplies your FDIC insurance, so you minimize your risk. But that's for another day. What else do we have on the legislative front?
Well, that was an example of an attempt to expand board powers. We also have many bills that are filed that are in an attempt to rein in boards. So one of the SB 1998 filed by Senator Jason Pizzo has a lot of onerous provisions that may become a little bit difficult for enforcement purposes and compliance purposes, most particularly, in my opinion, the issues with the official records, because official records are by far the biggest complaint made to DBPR in the Bureau of Compliance. I can't tell you how frustrated that I get dealing with official records issues, timeliness, how it's maintained, is it good enough? Did you have this? Did you have that? Well, under this new provision, it's going to specify that bank statements and canceled checks are official records. In my opinion, they were before anyway. Invoices, transaction receipts, and anything that reflects expenditures are official records. Of course, I believe that they were official records before, but it's going to require the associations to maintain those records according to division rules yet to be adopted in a manner that makes them readily available for inspection. Then if somebody makes a request to inspect the official records, the association has the obligation of creating an itemized list detailing every single record it made available for inspection. So what does that mean? Does that mean minutes of meetings 2017 through 2020? Or does that mean minutes of the meetings on March 12, 2017, minutes of the meeting on April 14, 2017, minutes of the special meeting for July 1, 2017? So again, that's a pretty high bar for associations to have to create these itemized lists, and then they have to attest to the itemized list. They have to basically, swear or affirm that the list was correct and accurate, and that any documents that were requested by the unit owner that were omitted are likewise specified in that list.
What about, is there anything, Lisa, in there where we can point a resident to a website that has, like in the condos now, you have to have, certain condos have to have websites, you have to have minutes posted, you have to have financial statements. Is there anything in the proposed legislation that would just say, everything you asked for is on the website, let me know if I can help?
That's a great point, because I did have that issue from a compliance perspective over the past year, where records that were available on the website, specifically, contracts for services and different things, we directed insurance policies, for example, we directed the unit owner to the website, and the division is of the position that that does not constitute compliance. So in this bill, actually, it does say if the records are posted to the website and you direct the people to the website, that does constitute compliance. Now, of course, associations have to make some considerations available for people that are not, computer savvy or computer users. But I do, this also says that by 2023, websites for associations are going to be required for communities with 25 units. And it says post all official records. Wow, what does that mean? Every time you get like a little Post-it note from someone saying somebody called, is that an official record that now needs to be scanned and posted to the website? That I feel is going to be modified to be more user friendly. And I'm a big fan of posting things on the website or having records available on a website, because it eliminates some of the personality disputes that can be involved. And it also eliminates some of the logistics and logistical burdens to both the association and the unit owner.
Oh my God, I completely agree. And we would prefer to be completely transparent. The data is the data. The facts are the facts. Just it's so funny dealing with some of these requests and some of the things they ask for. Who wants to tackle the collection stuff?
Oh, late assessments?
Notice before collection.
I did want to bring up a point about Senate Bill 1998 before we shift over, which was the official record requests, because I don't know how the managers who really are stuck fulfilling these requirements, right, have to simultaneously provide an itemized list to the requester of all the records. Imagine that, an itemized list of all of the records available for inspection and copying, and provide a sworn affidavit, right, that they are complying with the request and attest to the veracity of the itemized list. Then on top of that, any person who willfully and knowingly refuses to release or otherwise produce records with the intent to avoid or escape detection, arrest, trial, punishment for the commission of a crime, or to assist another person with it, is also then they are committing a felony of the third degree. So here we're trying to encourage people to run for the board, and now there's a new arsenal that can be inappropriately used to torment board members and managers with. I think there's a lot of room in Senate Bill 1998 for cleanup. We should be promoting good practices. We shouldn't be punishing the rest of the community associations in the state of Florida, the senator who put this bill forward, for the few bad ones out there that may have created official record request problems. Overwhelmingly, I think most of the associations comply and willingly provide these records. It's rare that you get into these issues that you would need an entire new bill redoing all of the association official record production around the state of Florida because of a few bad actors.
And is it addressing both? Is it addressing both condos and HOAs?
I'm not entirely certain on that one.
Me neither, actually. I'm not entirely certain, but
Okay.
you
It's
also have to
definitely,
consider the level of
condo.
sophistication of the community associations. Some are professionally managed by Castle and have great records and really appropriate procedures for filing things and locating items and delineating what constitutes an official record versus a non-official record. But some associations are self-managed, and you have, Aunt Sadie with, with a QuickBook program, and that's basically, and she gets the bills and she deposits the payments, and that's basically it. So are we imposing stricter obligations on community associations that may not be in a position to hire people to perform these services?
It's another example of governmental overreach because of a few bad actors.
Guys, on the websites, is it condos? HOAs aren't required to maintain a website. That rule is condo rule, right?
Condo only, condominiums, not condominium associations, but the condominium itself has to have 150 or more units.
And did you say, Lisa, they're thinking about changing that to 25 now?
That's what it would say here if you have 25 units or more.
Wow. Okay.
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 You asked about I'm sorry. Go ahead.
Go ahead.
No, you asked about assessment collection.
Yeah,
I know
that's the
Jeff, I
next
think,
one.
mentioned it too. One of the issues that came up in my practice over the past year is when is something considered delinquent? And if the notice of intent to become a candidate for the board of directors is due on the 7th of the month, and somebody has not yet to pay that particular month's maintenance assessment, does that mean they're delinquent? And I had to give the answer, yes, because if the assessment was due on the 1st, even though you have a 10-day grace period and it's not paid by the 7th, then they're delinquent and they're not entitled to be listed as a candidate. And that's unfortunate because, I have bill pay through my bank, and I don't control the exact day that the bank is going to actually send the check, nor can I control the exact day that the check is going to be received and negotiated. So that was a little bit unfair in that one particular situation. There's a bill by that addresses the Department of Business and Professional Regulations, and it basically says exactly that. If the person is delinquent, if the payment is not made by the due date as specifically identified in the declaration, condos, or bylaws, and if the due date is not specified, then the due date is the first day of the assessment period. So that doesn't change anything. That doesn't give you that grace
really
period or that leeway.
What about, I see a note in our notes for notice before collection, demand, and assessment notices. What's that all about?
Yeah. Before you can make a demand for the attorney fee when the owner is delinquent, you first need to send them a notice letting them know of their delinquency and give them the opportunity to pay before incurring attorney's fees.
Right. Okay.
They're also looking at bringing parity to both condo and HOA. I believe it's going to change condos to 45 days for the intent to lien and the intent to foreclose letter, which will match in with condo.
Right. So we're sending standard late letters that would cover that.
Yeah.
Definitely. But you know what is a little bit confusing, I don't think it's exactly clear through the language of the bill, is that you have to send statements of account. Does that mean that if somebody's late, you send them a statement of account? Or does that mean associations have to actually issue billing statements for assessment payments? And if they do a coupon book at the beginning of the year, does that comply with issuing statements for the due dates for payment? So
here's another
that
one.
needs to be massaged a little bit.
And what if there's a fine from the association in the condo setting, right, where you cannot collect the fine as an assessment? Does that belong on the statement of account? So there are some definite unanswered questions.
Good point.
Okay, well, we're winding down, and I don't want to leave without the promised debate on immunity for associations. So Lisa, tell us what's going on both nationally and in the state.
Well, this bill is, what number is it? It's House Bill number 7. Oh, so it's one of the first bills that were filed, and it talks about civil liability or waiver of liability for COVID-related claims. So there are some certain obstacles that a person making a claim will have to go through before they're going to be able to to prosecute their claim. So when they file a COVID-related claim, I was either prevented from doing something, or had personal injuries, or had property damage as a result of the failure to comply with COVID protocols, they're going to have to file it with an affidavit signed by a physician that is licensed, that actually talks about the nexus between the claim and or the activity that's being complained of and the actual diagnosis, disease, and what have you. So that says within a reasonable degree of medical certainty that the plaintiff's COVID-related damages are occurred as a result of the defendant's acts or omissions. I think that's a pretty high burden to get over. Plus, you'd have to show that the defendant, and our clients are, of course, the associations, failed to make a good faith effort to comply with any of the controlling authorities, so any of the CDC guidelines or the local orders. It's a big disincentive to making the claims. And you know what, if that's how it is applied, then I'm all for it, because litigation issues are speculative. We know from previous discussions that many of the insurance policies are not going to cover any claims that are related to disease or bodily injuries or allergens or environmental concerns. So anything that can be done to reduce the likelihood of additional litigation, I think is going to be helpful, not only for our community association clients, but helpful in the general community.
I agree.
Lisa, in reading the bill, would you agree that it seems like it's almost creating a standard of the association or any business, in order to have liability, would have to almost be grossly negligent before you're going to get to any type of liability by the time you're done with all those different standards?
And it also creates, I agree with you, and it also creates a 1-year statute of limitations.
Oh, nice.
So at least we'll have some, if this goes through, we'll have an end date, for the uncertainty.
That's fantastic. Okay, well, listen, Lisa and Jeff, we're going to wrap up. I want to thank you for participating this afternoon. Always a pleasure. I want to remind our listeners that our next episode is March 24th, and it's simply going to be a question and answer session hosted by my partner, James Donnelly. So look for that invite on the 24th. Again, I want to thank you guys very much. Stay safe, stay healthy. And to all our listeners, thank you. And we'll check in again in a month. So take care.
Thanks, everybody.